But 2 warrants of arrest have been released. How does this affect your case?
May I clarify that what the prosecutor did was to close her case. What that means is that she has no more witnesses to call and no more exhibits to produce. The next stage will be for the court to decide whether there is a case to answer or not. Now, if the court decides that there is no case to answer, that is the end of the case. However, on the other hand, if it decides that there is a case to answer, then the defense will be required to call their defense and produce their evidence. So that's how it is.
Right, but do you find these 2 circumstances, the closure of the case, the admission of Rule 68 and the issuing of arrest warrants, to be in any way significant to how you will proceed with your case?
Yes, it is very significant. If the statements that were allowed in under Rule 68 are to remain in place, then the nature of our submissions of no case to answer will be very different from a situation where those statements are not there. The contents of those statements make a lot of difference. And so, in actual fact, we would want the appeal chamber to make a decision on whether or not those statements are actually going to be part of the record and whether they are going to be part of what we are to react to in our submissions of whether there is a case to answer or not.
You know, this particular case, especially the admission of, recanted statements, has caused a lot of politicking. And I just wonder, what is your feeling about, your position at the court and how this case is proceeding? Do you remain very confident that this is a matter that will be dismissed, or do you see it going to full trial and it being an uphill task for yourself?
Yes, I have every confidence that at the end of the day, we will be able to demonstrate the innocence of the accused person.
All right, Katwa Kigen speaking to us. Thank you, sir, for your time. We continue now with other matters. Let's move to the teacher strike. The industrial court has declined